joined by my business partner, John Wiley, and by Outlier Patent's own Samar Shah. Thank you guys for being here today. We are going to talk with Samar about something he's been working on and something that we're super eager and excited to present to everybody. Patent pending made simple. So Samar, tell us a little bit about what this is, why you did it, and how is this going to change the world?
Yeah, thanks, Tim and John, and thanks for having me here. By the way, I really appreciated having a chance to talk to your audience. I think it's going to be really fun, and talk to you guys is always pretty inspirational for me. So I'm looking forward to it. Thank you. And I'll give you guys a quick background on myself. I am a patent attorney at Outlier Patent Attorneys. We do patent work for large companies, for small to mid-sized startups, scale-ups, as well as for individual inventors. So we kind of run the gamut in terms of folks that we work with. My personal background, big law, so I work with very large law firms, kind of AmLaw top firms. I've written patents for companies like Google and Facebook and many other Silicon Valley tech companies. That's kind of my background. And I've also done patent litigation work. So I work on high stakes patent cases for companies like Facebook and AT&T and a bunch of others, taken patent cases to trial, tried them in front of judges and juries, all the way up to appeals. So my experience has kind of run the gamut all the way from, creating the patent asset to going through the sausage making process of defending it or attacking it at the court systems and at the patent office. And now I, hopefully bring all that knowledge together to help our clients protect themselves from an IP asset perspective.
Sounds great. Samar, it sounds like you've been in this game for a while. It's awesome to hear your experiences, and you have absolutely, sounds like you have run the gambit. You have done everything that you can possibly do in this field. As more and more we are finding out about patent pending made simple, it just sounds like this is just a wonderful, powerful tool to help a lot of people in this industry. And what I want to do is I want to shift and talk about specifically, what was your inspiration in creating? Well, actually, first, let's clearly define what is patent pending made simple. What is it, and how does it work?
Yeah, thanks. I didn't answer that part of your question, so thanks for bringing me back here. But patent pending made simple is a software tool that helps you write your own patent application. And the way it works is it asks you a bunch of questions about your invention and takes your answers and uses an AI model that we've custom tuned with patent documents and patent frameworks, and spits out a patent that you can file with the patent office, or you can have us file, or any patent attorney file on your behalf. So that's what it is. It's a software tool that helps you write and prepare and file a provisional patent application. And, you kind of alluded to this, Tim. The inspiration for this actually started when I started this firm. So I started the firm Outlier Patent Attorneys about 5 years ago. Like I said, I used to work at a large corporate law firm that I left because of personal reasons. I was starting a family. I couldn't work the 80 hours and the constant travel that was demanded of me when I was doing high stakes litigation work. So I needed a better platform to support that. So I started that firm, but I was still working with, large enterprise companies. And that was going to be my main goal. A lot of my old clients that I used to work with at my old firm came over to our new firm. So I was primarily working with them. But eventually what started happening is that individual inventors or startups started knocking on my door. They were like, "Hey, I heard you're a patent attorney. Can you help me with this or this patent?" And, working with individual inventors wasn't originally a part of my kind of business plan. So, but I still, I like talking to people. I'm curious about what people do and how I can help, even if it's just like guiding people in the right direction. And I would sit down and I'm like, yeah, like, tell me about your product, like, how do you plan on making money? And sometimes, like the answers were great. And like some of these were like scale up products, if you will. And they really should should hire patent attorneys and put high quality patents together. But sometimes the products were more speculative in nature, right? Like we weren't sure if the product was going to go anywhere, whether it was going to make money, or sometimes the projections were we're only going to make 150K on this product over the next kind of a year to 2 years of its life, unless something really crazy happened. And I was like, in those cases, maybe you don't need to spend that much money right now, right? Until this product blows up. So I would always tell people, yeah, just go try to write your own application. I would send them book recommendations. And I even had copies of a few books in my office that I would hand out to people. I'm like, yeah, just like read these books and then write your pen application and you'll be okay for now. And then, if your product does well, come and see me, I'll help you. And that was the genesis of the product, right? I was just like, not everyone should be spending a ton of money on a patent attorney just yet. And there really aren't many tools to help people in that journey. Your only option really is to talk to a patent attorney, which can be quite expensive for a lot of people.
I've been in the IP game now for coming up on 20 years. I've been a patent illustrator, preparing patent illustrations, designs, product designs, trademarks, logos, working with patent attorneys. You understand why patent attorneys do gravitate towards the big corporate clients, because they don't shy away from paying their rates. They always say, like, why does it cost so much? Well, because it's worth it. I mean, they're bringing a wealth of knowledge and experience and things that are very beneficial to creating a very healthy, what I would call a healthy patent application. With patent pending made simple, which is a very clever, simple, clear title of what it is. Now, all of a sudden, people who say, hey, I got this new idea for this knickknack or whatever that I've developed in my garage, what do I do? Now, all of a sudden, there's access to it. And the other thing that is a big part of what the Patent and Trademark Resource does is education. There's a lot of businesses where IP protection is just not on their radar. What better opportunity for them to kind of break that threshold to protecting their IP than patent pending made simple?
I echo that. And I think it's amazing that you guys are putting all these resources together for inventors, because there isn't a whole lot out there, right? Like if you are an independent inventor or a startup, scale up, and you're trying to figure out what kind of IP assets you should file, what they're worth, you just don't know. Like, where would you go to even find those answers, right? So I'm really glad to hear you guys put these resources together and help the community in a meaningful way. I think it's going to help a lot of people. One of the things that I've learned in working and talking to independent inventors over the last 5 years is that they have multiple ideas over time, right? Because they're like, yeah, I have this idea. Sometimes it's a hit, sometimes it's not. But then like 2 years later, they'll call me again and they're like, I have this other idea now. And sometimes it's a hit and sometimes it's a not. And there's often no way to really know unless you go through that, go-to-market process. And you don't want to spend like 20 grand on one product when your third product could be like the multi-million-dollar product, right? So what I love of Pending Made Simple is that it helps you stay in the game, right? Like if you're an inventor, most likely you're going to invent a lot of different things. And you should be reading all the resources that are available on TPTR. And I think using Patent Pending Made Simple to just kind of get in the game, see what the market is for your product, and go from there, right? Without having to spend all your savings. And then you may come up with a game-changing idea and you may realize you don't have the budget for it at that point, right? So I like that about what we're doing, Tim and John. We're helping inventors stay in the game. It's amazing and it's important. And then with regards to the pricing tiers, they could get a little confusing, but we have 3 pricing tiers. So one is just by you, right? So and maybe I should take a step back here and talk about our process with the Patent Pending Made Simple a little bit. I think a good patent application has multiple tiers of abstractions or multiple layers of abstractions around it, right? So I almost think of a patent application as a Russian nesting doll, right? Like each layer kind of nest on top of each other. And I think that's what a good patent application should do. And that's what the Patent Pending Made Simple software helps you do. I mean, the AI is like, the sizzle, right? Everybody's like talking about AI. It helps us sell the product. But ultimately, I think it's the framework that we give people that's important. And that really has nothing to do with AI, right? That's just how we built the product. What we do is we start with kind of the narrowest layer of abstraction of your invention, your specific invention as you have come up with it. And then we say, what can we live without? How can we expand the scope of coverage? And we'll help you do that in the software. And then we say, okay, well, how can your competitors get around what's left? We'll help you describe that and protect that in the software. And then we say, how can we expand the scope of coverage by using broader terminology and words? And the AI does come in and help you with all that stuff, right? So that's the kind of the process that the software takes you on. I think it mimics the way I think about a patent application, or how a lot of patent attorneys think about a patent application. And I think it ends up giving you really good coverage on that patent document. So with that background, we have 3 tiers. So the first tier is just a buy you tier, right? So there might be people out there who are like, I'm comfortable with patent applications. I know exactly how to define it and write it up, but I need your framework to abstract things out and expand the scope of coverage. And that's what that first tier is for, right? We actually just take whatever you write in the question boxes, we take it verbatim and put it in our templates, in our boilerplate, and help you structure this patent application. So that's the first tier. The second tier is called the with AI tier, right? So it's basically the same thing as the first tier, but we use the AI to expand the scope of coverage, to potentially eliminate limiting words or dangerous words. I call it, patent profanity, and help you avoid all that. And then the third tier is the with AI plus attorney review tier, right? So this is the one that once you're done with it, I or another patent attorney at the firm will sit down with you. We'll, edit the document, review it, make sure everything is good. We'll also do a strategy call with you to make sure you're protecting the right things before you start writing the application. And those are the 3 tiers, and everybody kind of falls into various levels of comfort level with all this stuff. And the tiers are there for that. I would say in terms of our sales data, looking at the last 4 to 5 months, majority of the people have chosen the with attorney review tier, right? Because I think everyone is a little wary of AI maybe. And I think everybody prefers that safety blanket of having an attorney look at it, make sure everything's okay. It's not that much more expensive. So those are your options, but I think all of them are pretty good ones depending on your comfort level.
Thanks for going over that, Samar. I think the tiered plan is, we've been talking, as you know, with a lot of innovators and inventors, and now actually our reach is growing broader because we're bringing this more awareness to it. So we're getting, like Tim mentioned earlier, businesses coming in and having them give that option, because it's still an overwhelming decision, right? Oh my gosh, I have to do this myself. Oh, I don't, but I can save so much money and time by doing this, which I'd like you to touch on, if you don't mind, is not necessarily going through each tier, but what's the average time it would take somebody that wants to apply for a provisional patent and have it submitted?
Yeah, I mean, I'll say this, that if you work with a lawyer to put a provisional application together, it will take 5 to 10 weeks, right? So,
Wow.
You meet with them, have conversations, they write it up, they send you a draft, you give them feedback. Attorneys and patent attorneys are often busy, right? At my firm, we have backlogs. We try to keep everyone's backlog around 4 weeks at my firm, but at my old firm, our backlogs were closer to 10 or 12 weeks, right? So it could take a while before an attorney gets your patent application back to you. With the patent pending made simple, it's fairly straightforward. For most people, it takes under 2 hours to get through the whole thing. Most people that I've spoken to, we do exit interviews before, once people's applications are filed. And I always ask, how long did it take you? Most people, median is about 1 hour. And sometimes it could take more, sometimes it could take less, depending on the invention. But yeah, we've had several people who, purchased the software, one evening, and then, later that night, the patent draft ready for them to review. So very fast.
So there should really be no hindrance to accept one of these, of the tiers, right? Because just measuring that to the traditional way it's blowing the doors off of people.
Yeah.
And I tell you that gap, right? Like 10 to 12 weeks versus an hour, maybe 2. And especially, again, where we're coming from with businesses and individual inventors, doesn't matter. Like, time is money. Time is value. Time is a precious resource, right? So that's amazing to save that time and actually be able to get to market faster, to start selling and testing and get moving, having that freedom to do so, just super valuable. And so you said you do exit interviews with everyone who uses it. You get some feedback, but can you share some of the feedback, not just the time, but some of the feedback from? Give us a few examples of like first time inventors, the guys in their garages versus businesses like they've already filed a patent application before, but then they use this. So if you could share some of the feedback and some of their experiences with us and for our audience, I think that would be really helpful.
Okay.
Yeah, happy to do so. And on your time point, it's actually like very prescient of you guys, right, to kind of think about that and ask about that, because I've had conversations with very large companies, right, like one of the largest toy manufacturers in the United States. I had a conversation with, and they were like, "Yeah, we just want to reduce our time to filing," because if you think about it, like 10 weeks and 12 weeks is a lot for individual inventors, but for these corporate entities, right, they have like an internal review department. Somebody has to submit a form and somebody has to review it, and then their attorneys look at it, and then their outside counsel looks at it. I was having this conversation with the general counsel of a toy company, and they're like, "Yeah, well, by the time we come up with a toy idea to the time we file our first provisional, it's 9 months." And I'm like, "Wow, that's a long time, right?" And they're interested in the software not just because of what it does, but also because of the time, right? They can have their inventors and their toy makers just kind of submit stuff in there and get a patent on the other side. It's an incredible time-saving tool. So that's just one thing, and I've had several of these types of conversations. But with individual inventors as well, they say the same thing, that it is kind of a complicated process to like first pick an attorney, like who you want to work with. You hear horror stories about that as well, right? I had this one person who called me the other day for the Patent Pending Made Simple project, and he's like, "I want to do the attorney review tier, but like I had a bad experience in the past where I'm not going to get crazy bills from you after I sign up for this, right?" And I'm like, "No, this is it. Like the price you see is the price you pay. Like there are no other bills. What are you talking about?" But like that's kind of a complicated process and decision-making calculus, I think. But yeah, everybody has been so overwhelmingly positive about the software. They're like, it's so easy. And a lot of people have also said that we help them, like the questions we ask, with the layers of abstraction, help them even market their product better, right? Help them think through how to take their product to market, or how to, help it compete more effectively in the marketplace. So, I think that kind of helps. We help you think about your invention from different perspectives and viewpoints that you might not have thought about. But yeah, everybody says that the process is way smoother than they ever expected, and it's very, very straightforward. We keep it very easy.
Real quick, I just want to address one thing. You brought up like the stories of the attorneys, that there are attorneys out there. I call them milkmen, right? Because they milk you. They continue to milk you. They send you bill after bill, even years after the fact. And unfortunately, they are out there. Just know that that is not every patent attorney. We at the Patent and Trademark Resource have prided ourselves that we do not work with milkmen. We focus on working only with the trustworthy patent attorneys that, like, they're in for you. They're in it to protect you. Yeah, they're going to charge you money. It's going to cost money, but they're going to give you what they say they're going to give you. Part of our mission at the Patent and Trademark Resource is to shine a light on them, say this is a pitfall, watch out. And so just be aware that they are out there. And so again, thank you for bringing those up, because they are, and in my years doing this, I've heard too many horror stories of people going to these milkmen, and they have to go to a reputable, trustworthy patent attorney to try to get some of their money back, but they can't get any of their time back.
To your point, Tim, I get this, sometimes people call me and, we have very transparent pricing even at our law firm. And we're just like, yeah, this is what things cost. This is what we charge. And people come back and they're like, well, this other firm I talked to just going to charge me half of that. And I'm like, yeah, come talk to me 3 years later, right? Like, I bet you will pay twice as much with some of those firms than you would with us over the life of the patent, right? It's not just your initial filing that you got to think about. It's all the stuff that comes after that. And I'll say this, like, we also use like other lawyers, like we use European counsel or lawyers in other countries for our clients who want to file internationally. And every time they send us like a reminder letter that like, hey, you need to pay your fees. With it, they'll send me an invoice and they're like, hey, here's $125 for your reminder email. And that's just, part of practice. Like corporations pay those fees and firms may not think about that, but like that's like a infuriating letter, right? If you're an independent inventor, you're like, yeah, this is on my radar. Thanks for your email that you put no effort in, and now I got to pay a $250 bill for it. It's crazy, right? It doesn't work that way, I think, for independent inventors.
Yeah.
You brought up a very, very good point about that money, right? Because you Google like the cost of legal services, right? And you'll see numbers. You'll see low numbers like $199, but then you'll see like a little asterisk next to it. And then that asterisk can cost $10,000, right? So yeah, people need to be aware that just what you find on the information on the Google is going to say they're going to have a number. They're going to have, oh yeah, we can do a provisional patent filing for you for $199 asterisks. And just understand that, yeah, the asterisk is going to cost a lot of money in the long run.
Yeah, I personally, I just don't understand it, right? Like patent attorneys are expensive. Like I think our rates are on the low end, but we charge $400 an hour for attorney time. And if somebody's going to file your patent application for $199, right? Like how much time are they really putting in your application, right? Even our paralegals cost $200 an hour, right? And they got to go in and file your application. So, I just say buyer beware there, right? Like if it sounds like too good of a deal, it might be, like I've seen provisionals where the attorney didn't do any work, right? Like they asked the client to put a write-up of their invention and the client writes it up for a couple of paragraphs and those 2 paragraphs get filed. Like the attorney has never even looked at it probably. And then they probably got upcharged to have a paralegal file it for you. It's something to be aware of. So I'm glad you guys are shining a light on all that stuff.
Yeah. Well, Samar, and you guys are definitely, over delivering with this service, no way, as opposed to the opposite of the people we mentioned beyond a few minutes ago. One of the things that I want to just address before we wrap up here, when we're talking with our clients, we often get, well, okay, now I just have to wait for my patent to be approved. And our mindset is, okay, you don't have to wait. It's been submitted, but let's start working on the business model, right, to get prepared for when the patent is approved. But so what, in your mind, what's the next steps after they submit the patent? How long does it take to get approved? When do they get it back? What are your experiences on that?
Yeah, that's a really good question, John. With the provisional, you just get a filing receipt, right? So it doesn't get reviewed by the patent office. It doesn't get approved per se. It doesn't get rejected. The way it works is I kind of think of a provisional as a placeholder application. So you file it, and that's proof to the patent office that you invented this on this date. In the US, we're in a first to file system. So whoever files a patent on something first gets the priority to it, starting the date of their filing. So the provisional is nice. It kind of starts the clock on your patent date. So anybody who files a patent later will have junior rights or no rights relative to your application or your rights. So the provisional is nice in that way. The other thing that I like about the provisional is that you get another bite at this application, right? You have to convert the provisional into a non-provisional within 1 year, and that date is not movable. So a lot of my clients, especially the people who are using Patent Pending Made Simple, they file their provisional because they have an invention, but they also keep working on it, right? Like they're going to market, they're getting customer feedback, they're getting feedback from their manufacturers or licensing partners, and they keep refining their invention. And if you had filed a non-provisional, like if you want to capture those refinements, guess what? You got to file another non-provisional, right? You're just kind of doubling your expense, and it doesn't work that way for the for the conversion process. So you can file a conversion application a lot cheaper than having to file a non-provisional from scratch, and you can capture all those benefits. And that's kind of the beauty of the Patent Pending Made Simple software, because we help you expand the scope of coverage. There's always a risk that when you file that conversion application, you add new stuff, and that new stuff gets a new filing date because it can't claim priority back to your provisional if you didn't do a good job writing it, right? So by expanding the scope of coverage, we help you file that non-provisional and still be able to claim priority to your first date, which is also important. because it may help you stop certain infringement activity and stuff like that. So that's the process from a legal perspective. The other thing I'll add to this, John, is that there is a mindset issue as well, right? Like I find that a lot of inventors I speak with, myself, business owners, myself included, we sometimes have the imposter syndrome, right? That like, who am I to really invent this? Or like, like I'm sure 100 people have thought of this already, right? And you just kind of stop yourself, right? Sometimes get in your own way. I've had clients where I'm like, hey, yeah, this is an amazing product. Just get it out there and you'll make a whole bunch of money. And they're like, well, no, what if somebody steals it? And I'm like, yeah, like these are just mental blocks more than like actual blocks. And the patent pending made simple software kind of helps remove some of those blocks, I think, which I find very valuable. It's like, yeah, let's just go. Let's get the patent done. Get your product in the market. Start talking to Tim and John. Let's just get out there, right? Because that's the only way you're going to know. You got to start making money at some point.
Yeah, totally agree with you on that. I think people end up arguing for their limitations rather than looking outside of that.
Yeah, it's a great way to put it.
Unfortunately, yeah, absolutely. And one of the reasons why we can say that, I think, is because we've all kind of done that, right? We're all business owners. We've all dealt with this imposter syndrome. We've dealt with overcoming our limitations for the good of our business, actually for the good of our clients, right? That's one of the healthy reminders that we like to do, and I'm sure Samar, you're in the same boat, is reminding the inventors and the innovative businesses. It's not about the money you make. It's about the impact on the world you're making. Your gift to the world is you're going to get compensation for it, but look how many people it's going to help. When you look at innovation and you look at what has come out of innovation, and Samar, you kind of glanced on this earlier, that innovation breeds innovation, right? Even an inventor starts the process, files one provisional patent application, but as they're developing it and selling it, they realize, oh my goodness, like this is opening a door to a new kind of innovation, and they tack that on and tack that on. Next thing they know, they're on a whole nother level. All these tools, right? As we I just want to kind of, as we're closing up here, have a clear frame, right? What is it between the Patent and Trademark Resource and the patent pending made simple? Where we got time, money, and not just time spent filing and creating and everything, but time to the market, like hours versus weeks to get to market. Right. And money, we're talking huge difference in money from engaging an attorney versus having a high quality, trustworthy attorney reviewing the process. Not only that, let's be clear, right? If the attorney reviews it, they're familiar enough with your case that when it comes time to convert, you're already in a very powerful position, right?
Yeah, absolutely. I think I'll leave everyone with this one story for a client who used patent pending made simple. I don't think she'll mind, but she had a kind of, she had a stroke, right? She had a life-changing, debilitating issue. She actually one of the smartest, nicest people I know, but she lost part of her speech, right? Like she's not able to articulate herself as well as she used to be able to, and she came up with a product that helps address this problem that she has, right? Like super smart lady, and she was like, yeah, but like I don't have a lot of money. I don't know where to go, what to do. I'm like, yeah, the software, like it'll get you out there. Like, this is going to help a lot of people. And she used it. She got a provisional patent. She actually started talking to this elderly care home, and they were like, yeah, we'd love this product. So they licensed it from her. And then now they're working on getting a Medicare reimbursement code for it, right? Because like they're like, yeah, everybody should be using it. And now she's like, you know what? There are 2 or 3 more things where people with disabilities would really need, and she's working on those now. And it's like, it's such a heartwarming story because like this is a product help so many people, right? And if I know you guys feel the same way, we can play a small role in this journey to help other people. It's all worth it. It's all worthwhile. And if you think about it, like if she could have never afforded attorney's fees for this invention, like imagine all the lives like this product would not have touched, right? Or people who would not have gotten that help that they need and improve the quality of their life. I don't know. I think it's a journey for the good. And I think inventors should remember that as well, because sometimes you get too caught up in the blocking and tackling of bringing a product to market, running a business, and doing this and that. There, it's easy to lose sight of that even for us. But I think it's an important thing to remember.
The world deserves to see your product.
Thank you. So that is a beautiful story. And you know what? I can't think of a better way to wrap up this little episode here. Again, anyone out there, go to www.thepatentandtrademarkresource.com. Feel free to look up PAMS, PPaMS was our little acronym we like to do for Patent Pending Made Simple. Also, Samar, please plug your group and let them know where they can find you.
Yes, they can find us at outlierpatentattorneys.com or outlierip.com for short. It will redirect you to the same place. And, the link to Patent Pending Made Simple is on our website. Or if you just type in your browser, www.patentpendingmadesimple.com, it will redirect you to our website and the right place. So check us out. I, really encourage you to kind of at least think about it and learn more about it. We're going to start putting some resources together, I think, Tim, to help inventors. And I look forward to helping as many inventors as we can in their journey. So I'm looking forward to it.
Absolutely. I'm very excited about this business partnership. I mean, like I said, we have worked together in the IP field for a while, and to kind of combine forces and to combine outreach and to get out there and continue to help as many inventors as possible. I'm very excited to be on this journey with all three of you. I'm excited for what we can offer to the innovators of the world. Again, we are innovators. We are here for you, innovative businesses. If you have any questions, feel free again to check out the Patent and Trademark Resource. You can reach out to us on social media as well as on our website. Thank you. Thank you guys so much for this time. I'm excited about what we're doing and excited about what the future is going to bring.
Yeah. Thanks, Samar.
Me too. Yeah. Thank you guys for having me. I really appreciate it.
All right. Thanks, Tim.